Welcome to Thursfields Talk Legal, a vidcast series from one of the leading law firms here in the Midlands. I'm Steve Dyson, a journalist who's talking to a range of solicitors at Thursfields on legal topics of wide interest to the public or businesses. Today's episode is all about dealing with digital assets in wills and estates, and I'm going to talk to Ian Bond, Head of Wills and Estates here at Thursfields Solicitors. Hello to you, Ian.
Hello, Steve. Thank you for inviting me to take part.
No problems at all. And Ian, we're here to talk about digital assets. So first of all, I think we need to explain exactly what the term means.
Okay. There's no standard definition of what digital assets actually means. In short, anything is capable of being represented in digital form is a digital asset. Likewise, there's no exhaustive list of all the possible digital assets. We all know digital technologies now help us run our lives within the capability of our smartphones. Is the ability to book taxis, order food, play games, watch TV, do our banking and pay bills, listen to music, read books, meet strangers. The technology is endless, and from our WhatsApp, our Instagram, the pictures and texts on our smartphones, to our LinkedIn and Facebook and our commercial accounts like Amazon, all our email accounts, these are all digital assets. They all have value, and the digital world is in most aspects of our lives, and now increasingly it's in our death too.
You're absolutely right, of course. We all spend so much time online. But what happens to people's digital assets on their death?
It's a legal requirement to administer the assets of someone when they die. And some digital assets have financial value. So online accounts, e-wallets, payment mechanisms, they can all be valued. Our personal messages, our text messages, the emails, the photos, the videos, all stored digitally. They may have little financial value, but they have huge sentimental value. Sometimes these items are more important to the family than the cash in the bank. Losing them has a really emotional effect. And families want to protect that information. It could easily be deleted or lost. And caution needs to be exercised about the information. So, for example, on Facebook, it may not have any value in itself, but it contains information that allows others to get access. For example, it has information to typical security questions: mother's maiden name, date of birth, names of pet, which can all be used for accessing to bank accounts and other digital assets. So we have to be very careful about the assets that we've got on there and make sure that we look after them properly. Okay,
so once you've gone through that valuing process, Ian, what digital assets can you actually gift in a will, and how would that work?
Well, digital assets exist in electronically stored information as opposed to, say, printed information, such as ink on a paper. It's no longer sufficient to deliver a device, say the smartphone, to the relevant beneficiary without first investigating what digital information is stored on that device and whether it's actually capable of passing. Ownership of the device doesn't necessarily mean that you own all the rights associated with the information that's stored on it. Apple Music, for example, you only have a license to use the information, which is the music tracks that you download. You don't actually own those music tracks. When you die, the account closes with you.
The first thing that I think about when it comes to digital accounts, Ian, is the dozen or so passwords that I've got to access all those different types of online devices or social media or email accounts. I mean, I find it hard enough to remember these myself. So what are executors' rights to access them in the wake of someone's death? Do digital companies have to hand them over?
Well, due to concerns about security, privacy, identity protection, we all as individuals take a lot more care when managing our digital assets. And that includes using a variety of usernames and passwords. We have hundreds of passwords and they should all be unique. When we die, these can be difficult to find. We never advocate writing a password in a will. That would be out of date too soon. But we do recommend making an inventory of digital assets so your executors know at least where to start. And each company is different. There's no uniform way to access the digital assets. Each provider has its own rules. Now, most providers have explicit policies on what will happen following an individual's death. Some companies don't have policies, but when those policies are in place, we have to follow them. And most of the time, these are the policies that when you get your shiny new device or you sign up for the new digital service, they go unread. Most of us just scroll through to the end, click through to the agree, and carry on using the new toy or the new service. We don't actually pay attention to what those policies are, but they are there and we've all signed up to them.
To help viewers of this vidcast imagine what all this means, perhaps you can give me an example of how to deal with, say, your Facebook or your Google accounts.
Both Facebook and Google, they have legacy contact features. So they're settings that you can go through on your own account and put into place what you want to happen to your accounts after you've passed away. Now, for Facebook, you have the opportunity to delete the account or to have it memorialized and nominate people who can run the page for you after you've passed away. These are choices that you make in the settings. Celebrities like David Bowie or Whitney Houston have all set up memorialized accounts. So after their deaths, the nominated people contact Facebook, go through the Facebook process of verifying the death has taken place, and then follow the deceased wishes. Google similarly has an inactive account manager, which users can set up. So after a period of inactivity, whichever you want to set, it will check via email or a text message to you to make sure you're okay. If it doesn't have responses after a set period of time, after a set number of tries, then it will contact your nominated people with specific messages that you sent to them, notifying of the death and saying what to happen with their assets afterwards. And they will then use that information to contact Google to either download or delete or close the accounts as you direct.
Well, that's really useful, and hopefully other accounts and other online services have got similar things in place. And finally, Ian, for anyone thinking about dealing with digital assets in wills and estates, what are your top tips for going through that process?
The most important tip, the top tip, is to act now. So everyone should go through their smartphone, have a look at the digital assets they've got, have a look at the different things that they've signed up to, all the different accounts that they've got. One by one, go through the settings on these and select what you want to happen to those accounts after you've died. So they'll have different settings, different abilities to deal with them. And it's making sure you set this up and you put your choices in place so that it is not lost and gone forever after you've gone.
And for anyone wanting further reading on this, I understand you've written a chapter about digital assets in a law sector book, haven't you?
I've got a chapter on digital assets in the Law Society's Probate Practitioner's Handbook. The latest edition is out in January, so just after Christmas, but it goes through in a lot of detail about how people can deal with their assets before they pass away, and also once they pass away, how executors can get the access.
Ian, many thanks for shining a light on this area for us. If anyone wanted advice in this area or the wider challenges of making a will, how can they get hold of you?
You can contact me via LinkedIn or Twitter. So my Twitter handle is @IanBondTEP, or the usual contact. So my Thursfields email address, ibond@thursfields.co.uk, or the office number 0121 796 4027.
Ian Bond, Head of Wills and Estates here at Thursfields Solicitors. Many thanks for joining us on Thursfields Talk Legal.
Thank you for having me.
Hopefully what Ian had to say about dealing with digital assets in wills and estates is something that people will find useful. We'll be back soon to talk to more legal experts here at Thursfields about other interesting aspects of the legal world. Thursfields Talk Legal. Thanks for listening.